electricity distributors to use a cost of supply study or cost of supply as a basis for their tariff applications from the 2024-25 financial year. So this plan is put in place in order to comply with the court judgment of the 28th of October 2022, where the judge declared the use of the guideline and benchmark to set tariff as invalid and unlawful. So this plan, Chair, is premised on a number of interventions or pillars. The main one being the reviewing of the current cost of supply framework to replace the guideline and benchmark methodology. It's also is premised on the rolling out of an automated cost of supply model that will be used by licenses to put together their cost of supply studies. It also requires collaboration with a number of stakeholders to assist the regulator for municipalities to comply. And part of that plan is to put together a communication strategy around, first of all, informing licenses that they need to, from the next financial year, all tariff applications have to be submitted by a cost of supply. Part of that plan is also to inform licenses in terms of the expectations from the regulator, as well as the support that will be available for licenses in order to comply. So also as part of the plan is some other capacity building for municipalities that needs to be put in place for them to be able to put together and then submit a compliant cost of supply studies. So the report also provides a status report in terms of compliance. As at this point in time, we have 8 licenses that have submitted compliant cost of supply studies, and others have submitted studies that are currently being considered by the regulator. So as part of the plan, the rollout of the cost of supply model is also recommended because this model automates the whole process of conducting a cost of supply study and is based on the NESA framework. So the model also addresses some of the concerns that were raised by the judge, that it allows for the tariffs that are charged by licenses to be linked to the cost that is related to supplying each customer. So the input costs into this model are your DFOM information, your financial and technical information, ESCOM bills, and other documents that or files that are normally required by licenses as part of their tariff application process. So using this model will sort of expedite the process of all licenses complying with the framework. So a lot of work has been put in place by the regulator to support municipalities. For instance, we developed the minimum information requirements that should be part of the cost of supply study. We've also developed asset register proxies that allow licenses to determine the value of their assets. And we're also working with a number of stakeholders to assist licenses to comply. So I would like the Electricity Subcommittee to note this report. Thank you, Chair.
Thank you. Members, the report is here for noting, but before we note it, are there any questions? Again, members, be guided by the fact that any matter that's deemed to be of governance in nature, we can deal with it when we have a closed session. Any comments, questions, members, on the document before us? It is here for noting. Madam Spear.
Thank you, Chair. Thank you to the presenter and the whole team for the presentation. Chair, for me, it's a general concern because obviously we are all aware of the High Court judgment, and therefore the judgment also giving the 12 months to rectify the whole thing. But then I link it then to the fact that, as stated in 4.2, that municipalities themselves are actually struggling because, as also the presenter has confirmed, only 8 actually out of, we all know the number is more than 100, actually more than 200, were able to implement the course framework. So for me, the challenge is just to ask the team, looking at the deadline, which is the 12 months, and the challenges that are being faced by the municipalities. Yes, I hear you saying that we are looking at capacitating them in order to make sure that they have these studies. Is that achievable? We have to comply. That I'm aware of that. But the issue for me, Chair, is from that side of municipalities. Any other intervention that we have looked at in order that the municipalities, whilst we are complying as NERSA, they are also assisted to comply, because there are serious issues out there at municipalities level, because one of them is the data issue that exists there. Have we looked into that and got assistance from COPTA, etc.? Thank you.
Thank you, Madam. Clear questions. Mr. Mkhize?
Thanks, Chairperson. Yeah, I've got just a few questions from my side and clarifications sought. Maybe to start off at a high level, my understanding is that we've got a situation here where there is a cost of supply framework, and we are saying that the municipalities that are ready, they can still go on and use that whilst we are developing the benchmarks that are not currently in terms of consumption, but are based on the cost of supply, and then that is going to be used in instances where they've used the framework as is, or where there's no information that is provided. Just want to get that clarity so it's unambiguous. That is in case my understanding is not correct. Under 6.1.6, you're saying that building capacity within municipality to conduct compliant cost of supply studies. I note you have mentioned the issue of GIZ. I think it's going to be important to come up with to be clear with the ramp-up plan, which will even talk to using consultants to expedite, especially the first part, to assist. I'm not getting the comfort that this is going to be expedited enough before they are due for the application and for consideration from our side to be able to not ask for any extension of deadlines. So if they can get that one, that clarity. And it is my understanding that if no cost of supply study is provided, then the benchmarks, but not the benchmarks in terms of what we are currently using, the consumption-based tariff-based benchmarks are going to be used, but the efficiency, the cost of supply and efficiency-based benchmarks are going to be used from our side, which then translate into the cost of supply-based cost and efficiency benchmarks being on the critical path in terms of this project. So when one looks at the development, you've got it until the 30th of December, which is aligned to everything else here, which then becomes a bit of a concern, because one would expect it to kick in earlier, because then it forms the basis, it informs others. Looking at the plan, it becomes difficult to see what is actually sitting on the critical path. Right. When I get to the just on the plan itself, in terms of what is in the table provided, we've got the one for 15 May that is ending on the 21st. That is the review of the cost of supply framework. Just for confirmation to check if are we still on track with that or not, as well as also when I look at the issue of internal capacity building, when will this online training portal that is under development be activated? I think it's going to be important. What actually lags in a way in terms of the activity. I think we've written the milestone as an activity, and actually not have the key activities listed. I think there is a column that should talk to activities, the main activities, because that then gives you a sense that we are indeed on track and issues are going to be addressed. For example, if you development of efficiency and cost benchmarks, all right, one would say would have to indicate the milestones, the milestone that becomes a milestone, and then have the activities, and then clearly indicate how far the process is to give comfort that these are going to be done, because all I'm getting here is that everything must be finalized by the end of this calendar year for municipalities to then ready themselves and do everything to be able to launch their applications. And then in terms of capacity building, again, to say ongoing, I think it should be clear as to when is it going to be reviewed, and not just have ongoing, because it doesn't give a sense of being time conscious in achieving those activities. And again, the listing of activities, the key activities, and getting a sense of where we are and by when we're going to finish. And then you're talking of the approval of cost-based tariffs. You're also saying that this is ongoing and it's not dependent on the finalization of the review of cost of supply model. Just correct me if I'm wrong. This then, we should be explicit that it does depend on the development of efficiency and cost benchmarks from our side, so that you are clear that then becomes a key element. Times are provided, and thanks also for the annexure where we have put the plan, in the narrative of the plan. But still, one should, looking at that, have the comfort. And also, when it comes to data, I would like to know what is a time lag, because we always understand that there is a time lag, but what time lag are you envisaging in the short run as well as in the long run? If you can just indicate that, especially when one looks at 4.2 on page 11, the green page 11, when we look at those that have supplied those 8 municipalities, and then you're talking of the 40 supply studies that are either currently being reviewed by NERSA or in the pipeline of being reviewed. And you're talking of that information being as old as 2018. So if you can just assist with that clarification, I rest my case. Thank you.
Thank you, Mr. Mkhize. I don't know, welcome Mr. Pokula. I don't know whether members, are there any further questions, or should we just hand over back to management for responses? I don't see any further hands. So Mr. Sichotlo and team, please respond.
Sure, let me first give it to Ubongani, and then after that we'll patch up where he's not filled up the gaps.
Thank you, Dr. Conjola.
Thanks, Chair. So I'll talk about, I think, the operational issues, and then maybe Mr. Sishotlo can assist in terms of the capacity building around consultant and additional resources that will be procuring. So in terms of the first question from Dr. Sibia around whether this is achievable, by ourselves, it is not going to be achievable. So that's why if you look at the report, there are already stakeholders that are there to assist. So we also have meetings that we have with other stakeholders such as SALGA. There is a work group that looks at cost of supply. It consists of a number of stakeholders, such as SALGA, National Treasury, and DBSA. So it looks at certain interventions that you can put in place, and assistance that you can get from other stakeholders for us to be able to achieve this. But on our own, definitely we won't be able to do this. We need that assistance from other stakeholders. So there is work in terms of work groups that are there that are assisting us to achieve this. So, and then in terms of the benchmarks, I just wanted to clarify. So when we put together this plan, we also had a meeting with the legal team just to advise us in terms of what are the implications of the court judgment around benchmarking. So what was clear from that meeting was that we cannot use benchmarks to set tariffs. All licenses must submit a cost of supply study and all the tariffs must be based on the cost of supply of each municipality based on its own cost of supply. What we can use benchmarks for is to test the prudency and efficiency of the costs. That is by identifying the best performance in the industry and then use that to test the efficiency and efficiency. But in terms of setting tariffs, all licenses need to submit a cost of supply study. And what Advocate Murati also emphasized was the fact that when this court case started, municipalities were also the respondents. It wasn't just NESA that was a respondent. So all municipalities were copied as respondents. So it means that they are aware of this and they are sort of required to comply with this requirement. So yes, we'll still use benchmarks, but from a point of view of testing the prudence and efficiency of costs, but not to set tariffs. So the ramping up of this plan around the capacity within municipalities, we will provide details as more information becomes available, and once we have certain dates that are there. So the training is already started. Currently, we are already internally having our own training, capacity training this week. So, but as we schedule more meetings in terms of the capacity building for municipalities, we'll update the plan. So as part of that, this report, we said we'll provide an update every 3 months to ELS and at least once a month to management internally. But we will update what we are doing in terms of the capacity building. So in terms of the critical part, yes, Mr. Mkhize, because the benchmarking is a requirement for us to be able to sort of do the prudence and efficiency, it is a critical part, because when we start analyzing these studies, we'll also, as I said, that we need to identify those that are performing according to technical and financial standards, and then use that to benchmark others. Because as a backup plan is that once we, unfortunately, because as I said, we cannot use a benchmark to set tariffs, but we need to be able to have a means to test the prudence and efficiency of the cost. So yes, it's a critical part. So the development of the currently, what we have done is that Recovery has assisted us to link the deformed data, which is financial and technical information that we receive from municipalities every year. So already it allows a system to extract this data to be put in a model that will already assist us in terms of developing benchmark. So there's work underway around that. I don't have the confirmed dates, but when we come back to ELS, when we update with all the activities and sub-activities that we need to do, then we'll have the confirmed date. And that also includes this online training portal, which I know it's currently under development. and we are being assisted by one of our stakeholders to develop this online portal. And then also maybe I would at this point allow Mr. Sisotlo to come in also in terms of the other areas around capacity building. Thanks.
Yeah, no, Bongani, I thank you, but I think now we are getting into those areas that we said should be discussed as operational. I think what you've answered is content, and I'm happy with that. Unless if members have got more, can we just stop it here, Babu Kumete, and then we can talk about how do we take it forward internally as NERSA without taking it to stakeholders. Thank you, sir.
Thank you, Mr. Chotlo. And I think, as you rightly point out, capacity issues are internal matters that we'll discuss. So if you can then just note those questions. So we'll then revisit this item in a closed meeting, I guess as a combination of item 5 and 6, because these two are actually related. So members, there may well be questions that have not been responded to. Apologies, as we indicated, to hopefully deal with them under once the meeting is closed to the public. But I'm hoping that the matters that the critical matters have been responded to, and the matter is really just here for noting. So it's something that will be we'll have to continually be discussing internally for the next up until December, because it is a critical issue for us in terms of how we actually set the tariffs for municipalities next year. Mr. Pokola, I note you. If we can come in, sir.
Thank you, Mr. Gumede. Apologies for being late, although I indicated to you that I'll be a few minutes late. Mr. Gumede, my input on this particular matter was that we seem to be focusing on what we are going to do on the cost of supply studies and our own capacity building. We're not, I mean, our function is going to be to assess them. But we're not the ones who must do the cost of supply studies. It's the municipalities that must do the cost of supply studies. And I thought part of our plan would be whatever we are going to do to ensure that we get them to do it and assist those who can't do it. And the second part of what I thought we would have is that I can say now that 90% of the municipalities are not going to have this cost of supply study by the time they have to do this. And not 10, 90. And on that, we need to have another route, whether it's the one that's straight or the second one has to be that they have to. I mean, in the policy, I just haven't checked what it really says, but there's got to be a way of them requesting an exemption or a condonation or something from the regulator to use whatever other method that the regulator would use for them to have their tariffs approved. But I didn't get that sense. Maybe it's going to be discussed elsewhere. But I think for me, I thought there will be a total strategy on how this thing is going to be done, because we're not the ones who do the cost of supply study. I mean, we can do all the capacity building we want to do, but we're not touching where it matters most. Thank you for the opportunity, Mr. Gumede.
Thank you, Mr. Pokola, for your input. Yes, indeed, the issue has been raised about capacity issues. Clearly, as you clearly indicate, it's not just internal capacity, but it's primarily capacity for the Munics, and also we need a backup plan for those, as you rightly point out, for those that will not be able to supply to supply this. So what then do we do? So can I request, members, that I think we've deliberated on this matter, and I think in terms of the public out there, it's quite clear what the issues are that the regulator is dealing with, and especially issues that are outside of the regulator's control, if you like. That is the activities that are undertaken by the municipalities themselves in this particular case. So yeah, but can I then request that we discuss all of the issues relating to capacity, as Mr. Pokola is saying, it's not just about. In fact, It's not even about our internal capacity per se. It's the capacity of the municipalities out there that need to supply this, that need to conduct the studies, as well as, of course, then having a plan B. If that fails, what is plan B? So can I then request that we deal with that in a closed session, and that, as requested, that we note the actual report with all of the concerns and issues that have been raised by members. If you don't mind, members, by show of hands, if we can just note the actual plan with those issues, and then we'll actually revisit this in a closed session. Thank you, Mr. Bokula. Thank you, Mr. Mkiza. Thank you, Advocate Setole. Madam Aseti, Madam Spear, are you happy to note? Thank you, Ms. Spear, and thank you, Madam Aseti. I'm also happy to note. So as we're saying, we're noting at this stage, but we really need to revisit this. As Mr. Bokula puts it nicely, we need a total strategy. And a strategy, hope is not strategy. We need to have strategy, and then we plan for the worst and hope for the best. Thank you. Let's move on. Let's step off this and go now to item number 6, which I guess is linked to this issue that we've just raised. But can I hand over back to you, Mr. Sechotla and the team?
No, thanks, Chair. We should have actually started with this item before number 5. But I think Ubongani will continue on the very same spirit, knowing what the members' concerns are. But I think already some of the issues have been raised by members. The submission is about a consultation paper on the very same issue of the cost of supply. So it continue as though we are still dealing with the same item. Bongani, it's your show.
Can I guide differently and say, so this one, because Mrs. Chotlo, you are requesting ELS that you publish a consultation. Can we just focus on the consultation paper on this high level, on the issues that you are raising on the consultation paper, so that, and then of course our members can then give them comfort that the consultation paper, the consultation would actually yield. Let's just focus on that. And because the other parts we've dealt with under item 5. Dr. K, please proceed.
Thanks, Chair. Yes, so we did actually request it to be arranged this way because the consultation paper is part of the plan, so it was deliberate to group this way. But Chair, so the purpose of the submission is to request the ELS to approval to publish the consultation paper, as well as the associated timelines. So the consultation paper is to review the current cost of supply framework. The current framework was approved in 2016, and over time, when we're trying to get licenses to comply with the framework, we identified a number of areas of improvement in terms of the consultation paper. So some of the areas is that, for instance, it's limited in terms of how you test prudency and efficiency of the costs. So because now we'll be using a guideline and benchmark, we need to establish a mechanism to escalate tariffs from year to year, because the cost of supply study is done once every 5 years, or when there are certain changes to either cost structure, customer base, or of a licensee. So also in the current framework, there is no provision in terms of how you ring-fence your electricity business from the other business of the municipality or any other entity. And we are also proposing some changes to decouple the approval of municipal tariffs from the approval of ESCOM rates, because there is a challenge every year that before we can do municipal tariffs, we need the ERTA, approved ERTA. So we are proposing some ways to address this problem so that you can start with the approval of municipal tariffs earlier. So some of the specific recommendations or proposals in the revised framework is around how, in terms of how you treat repairs and maintenance costs. There's also a proposal around the issue of sales. Also, how do you calculate the regulatory asset base? And we also added a new methodology, because the current framework only speaks to the cost plus methodology. So we've added a section that also gives licenses an option to calculate a return on assets based on an approved return. We're also proposing expanding the section around the rate setting, so that we try and standardize the rates that are out there. So in terms of the project plan, Chair, we hope that this consultation paper would be approved by the ER of the 26th of October, after having undergone the consultation process in terms of stakeholder comments, public hearing, and as well as a webinar to bring all the stakeholders to discuss the issues around distribution revenues as well as tariffs. So, Chair, in terms of the consultation paper that is going to be published, I do apologize that this version has not been language edited, but we did receive a version that is language edited on the 26th of July. So, but due to timelines, we couldn't update the link, but we have received that. So this is the revision that will go out to the public. I think I'll stop there, Chair. Thank you.
Thank you, Dr. Konjelai. Members, can I then request again, with an understanding of the process that's been proposed here, is that I guess what we are trying to do is just to invite the public to join in and participate in this process. But there's clearly gonna be a need of at least a very comprehensive pre-hearing, pre-public hearing meeting or engagement with the members, and of course also a post hearing as well as the other processes that have been proposed by the team. I guess therefore, and also noting the comment raised by Dr. Konjelai that with the apology, that the version of the consultation paper that is here has not been language edited. So there is an apology, also if you can accept that apology from my side as well, and therefore maybe let's not so much deal with the language issues, with the hope that those will be dealt with extensively before this paper is published. So members, I guess the team is just here to ask that the consultation paper be published, so that at least we can then also bring in the views of the public out there, especially those of the municipalities that have to actually submit these things. So with that, members, can we maybe just look at it from that narrow focus? If I can then open it to you for questions and comments. If there are any particular questions on the consultation paper with those provisos that I've made. Apologies for constraining you if I did. It was not the intention. I see no questions, but I do know I have picked up, Mr. Mkiza, also a number of grammatical errors here, but and some of them do change the meaning of what is being said. And the hope is that those will be dealt with extensively before this paper is published, before the consultation paper is published. Mr. Mkiza?
Thanks, Chairperson. For some reason, seem to have lost my annotations, but let me just talk to the issue of the project plan itself, as it is put forth. That consultation period that is there, I'm not so sure whether we are going to, we're not going to be facing the challenges, or it includes the comments that are the comment period that is the 30 days that is included. So that consultation is the actual activity now in consulting. Just want to, if I'm reading it correct.
Mr. Mkiza, we seem to have lost you. We seem to have lost Mr. Mkhize. However, I think the question here, fundamental question, is to what extent does it comply with our processes? Does it include the period, allowed period of 30 days for the stakeholders to return, as well as then having the actual workshop or the actual public hearing?
Yes, thanks, Chair. So when we did the calculations, yes, we did take into account the requirement for 30 days for stakeholders to provide comments. At the same time, we also, when we issue this, there's the advert for this, will also include the requirement, the day requirement in terms of the notice for the public hearing, which we proposed for the 15th of September. So the calculation is that we'll publish by the 3rd of August and allow the 30 days for stakeholder comments, and then have a public hearing around the 15th of October. So I think it complies with all the statutory requirements. Thanks, Chair.
All right. By the way, Dr. Konjela, is it possible that you publish just for members to give comfort to the members, publish the edited version as well, even if it's just for information, so that the members at least would know the version that has been published? Is it possible to share that with the members?
Yes, we'll do that, Chair. Thank you.
All right, thank you. With that, members, I don't know if there are any. We seem to have lost Mr. Mkhize. He had a connection challenge. But with that, can we then perhaps then, if it's... Are you back, Mr. Mkhize?
Yeah, I'm back. But I think it's fine. We may proceed with it, because I think my understanding of the consultation period was, it was 1, and 2 was the issue of saying my understanding that some of the things that are not necessarily incorporated here are going to be incorporated in the consultation on the benchmarks themselves. For example, as I said, the issue of repairs and maintenance in terms of looking at the 6% vis-a-vis any other percentage that could be applicable based on, for example, the categorization of the reputed asset base itself. If my understanding is correct in that, then I'll be comfortable, because there would be no need to ask certain questions that would pertain to the benchmarks. If my understanding can just be confirmed to be correct, I'll be happy then to support the approval for the publication. Thank you.
Thank you, Mr. Mkhize. Can you respond to that, Dr. Konjela?
Chair, so I'm not sure if I did understand the question correctly. Maybe colleagues can assist. But my understanding in terms of the benchmarks, there is a section where we proposed that instead of using the benchmarks based on consumption, we would use the ones that are based on the cost of supply. I don't know if that was the question.
Mr. Mkhize, can you clarify? I understood it differently, but can you clarify it? Before I recognize you, Mr. Chotla, so that we are quite clear, Mr. Mkhize, can you clarify your question again properly? I understood it differently.
Yeah, what I was trying to convey is that you would have a situation where we're not asking specifically, let's say, on the 6% of the total cost to be for repairs and maintenance, but that will be dealt with when we are looking at those benchmarks that are not consumption-based. If you've got, for example, to add a surplus, you've got 15%. For example, to say, why not 10%, why not 20%? That will be part of what will then go into that benchmark exercise. I hope maybe I'm understood there. And that when it comes to depreciation, for example, you'll have a situation where the depreciation that one will be looking at, there could be situations where there's accelerated depreciation, but to incentivize some assets in future. But for intents and purposes, we're looking at depreciation in terms of a straight line currently. There are issues of vandalism. All of those things will then come in when one looks at benchmarks. That was my understanding. You can correct me if I'm wrong. And cases where there are data challenges, to say, where do we weigh in then in terms of data, assuming or taking a particular stance regarding data, where it's more like if you as a municipality don't provide the data, we consider that data to be this, because that's what maybe we talk to the issues of benchmarks and trying to get this process done soon. That is my broad understanding. Thank you.
Thank you, Mr. Mkhize. Mr. Sichotlo, do you want to respond briefly? I hope the question is clear now.
No, I think I understand Mr. Mkhize. But Mkhize is saying that, okay, let me put it this way. Our strategy is to get those that can do the work to do the work. And those that cannot do the work, we'll try and actually sample them and use statistical things. And then after that, we'll then say these kinds, for instance, the repairs and maintenance, the 6% was based on a benchmark, but that benchmark was very general. But now we're going to get into the deeper one and find a benchmark that talks about those that have got the capacity, those that don't want to do it, those that are doing it, but are not doing it sufficiently. So it will be based on very close to what you can achieve. I don't know if you understand me, Babu Mkhize. That's what we are trying to do.
Okay, colleagues, can I guide on this one? So, Mr. Mkhize, from where I'm sitting is that what we are asking here is, from what I understand, that there are two types of consultations. We are currently consulting on the methodology. We then have a general landing on the approach. That does not preclude us consulting on the implementation stage. Now, once the methodology is put to bed and all of the concerns raised by stakeholders, concerns that may talk to data, may talk to capacity, all of the concerns have been consolidated. That will then affect the actual implementation. So what is being consulted on now and the timing that is before us is actually on the framework itself, that we can't proceed until we have concluded what whoever is, whether those people that have the capacity to do something, and whether those people, we need to be able to conclude on that. And those that have capacity are able to do this can then, based on that framework that would have landed on, that those can then proceed. And those that cannot, categorized, coming up with Plan B as asked for by Mr. Pukula, we may have to consult on that. So I guess what I'm asking is that, from what I'm looking at here, the team is only at this stage not consulting on the numbers, which would be an output of the framework itself, because the framework will determine what the approach that will be undertaken. Once the framework is bedded, which the hope is that is bedded by the 31st of October, once that has been put to bed, the implementation, there will still be implementation challenges for those municipalities that will not be able to do this. There needs to be a plan to deal with those. And that plan might still need to be consulted on, as much as we consult in terms of the municipal guidelines. But the first consultation is only on the framework. I'm hoping that is clear. Mr. Mkhize, would you be comfortable with that?
I'm comfortable with that. Let's proceed then on that basis, because the other thing, just for example, even on the what do you call this? Even when one looks at affordability, when one talks of cost of supply, for example, you envisage that for the low-income households or rural areas, there's a likelihood that the cost to supply there will be higher than the more affluent areas, say, for example. Then when you're looking at the cost of supply and you're looking at just the tariffs and everything, you then have to then look at the issues of free basic electricity, the threshold there, look at subsidies as a separate issue, the consultation on those. So you may not necessarily go to town in terms of what you have here, with the understanding that there will be some process when it comes to the actual implementation that will have taken care of this free basic electricity and other matters related to subsidization, to really have a properly working system. That is my understanding, and it is on that basis that I say I support this, because someone might ask why certain aspects we did not go to town with the understanding that they are going to be dealt with elsewhere. Thank you.
Thank you, Mr. Mkhize. Mr. Chotlo, can I kindly close on this matter? I think
I'm covered. I'm covered. Thank you.
All right. Thank you. So for me, I think, colleagues, the issue here and the question asked by Mr. Mkhize is a valid one, and it talks to the overall strategy, because unfortunately regulation is about data. If you don't have the data provided by the applicant, you need to then have a plan B in terms of what proxies are you going to use? Will those be deemed necessary, for instance? And the issues raised by Mr. Mkhize around certain concerns that, for instance, if this particular framework is applied, what happens to the sparsely populated areas where the actual cost to serve will be a whole lot higher to the very people that can least afford. So those things are part of the implementation part. Hopefully those things would have been unearthed during this phase. So colleagues, if we don't mind, can I then guide us to a decision, please? The decision that is really required is, as I think the way I put it earlier, let's bring the stakeholders into the fold. Let them guide us as well on this. So as we discuss internally, we need to also then invite the stakeholders. This is what is in essence essentially being asked, and then it's also asked that we then approve the indicative timelines. That is, at least those are the guiding principles. Those are the timelines that will guide us in terms as we take this process forward. So members, that's on paragraph 14.1.1, approve the publication, and then secondly, approve the indicative timelines. By show of hands, members, if we can do that, if we can vote on those two issues. Thank you, Mr. Mkhize. Thank you, Madam Spear. Thank you, Advocate Sithole. Thank you, Madam, and thank you, Mr. Pokola, and thank you, Madam Massetti. All members have approved. Remember, though, your promise, Mr. or Dr. Konjela, you please share the latest document with the members so that at least we can be comfortable in terms of the content. Thank you. All right, so can we then step off this one and go to agenda item number 7? Mr. Sichotlo, who's presenting this one? Zintakel, Madam Masike, who's presenting this? Okay, please proceed.
Yes, Chairperson, thank you. I will take you through the submission. So this is, Chairperson, a request to approve the publication of the EPDM rules consultation paper and its indicative timelines, and also to recommend for the energy regulator to note the publication. So just a bit on the background, this process started around 2021, where there were principles that were developed to inform the EPDM. That was followed by the publication of the consultation paper to allow stakeholders to engage on the EPDM. And that process of public participation was also followed by the development of the regulatory report, which is the one that is informing the rules which we are requesting the approval of its publication. There were a couple of workshops that were held. The last one was held on the 13th of July this year. There were several issues that were raised. Those issues are captured on the table under paragraph 6.4. And then the rules and the consultation paper is attached. They are attached. The rules are attached as Annexure A, and the consultation paper is attached as Annexure B. And then a bit on the rules and the consultation paper in terms of the content. The first chapter of the rules deals with the title and the definitions. And then the second chapter deals with the legislative mandate, and we are inviting members to give us comment on the legislative mandate. There are questions that are raised. There are also questions under Chapter 3 that are raised on the industry structure, which is under page 49. There's also a section that deals with the principles, and there's also there are questions around the principle and the 5 steps, which are revenue requirements, cost functionalization, cost classification, cost allocation, and the rate establishment. And there are also questions that we are inviting stakeholders to comment around the 5-step process of the EPDM. And there's also an area of revenue requirement methodology, which is a key component of EPDM, which is under page 51 and 52. And there are also questions that we are inviting stakeholders to comment on, and also consumer demand analysis. And the last one under Chapter 3 is the consumer pricing and its build-up formula. We are requesting stakeholders to give us their view on that. There's also Chapter 4, which deals with supply-side data or information to be generated by the licensee, which is financial and non-financial information. And then Chapter 5 deals with the tariff application process, which we also invite stakeholders to comment on. The Chairperson, that is the consultation paper that we are requesting the committee to approve its publication. The recommendations are on page 9 and 10. I thank you.
Thank you, Mr. Ntakeni. Members, similar to the previous one, I guess the issue here is that we are just inviting the stakeholders to also participate in our broader thinking. And clearly on this one also, there needs to be a comprehensive pre-hearing, as well as a comprehensive post-hearing, as well as other processes that may be embarked on in between. So that, in essence, is what this one's about. And again, it's about just asking for the paper to be published, and so that we can actually bring the public into our confidence in terms of our thinking in respect of the broader industry plus determination. So members, any questions, comments on this? We have dealt with it. I guess we've had a workshop internally. Madam Massetti.
Thank you, Chairperson. Chairperson, maybe we can, since we have dealt with the cost of supply framework for the municipalities, I think it will be important to clarify the scope of this EPDM, whether it's not going to be applicable to distributors. It will only be applicable to Eskom, but also Eskom is a distributor as well. So if we can just clarify in terms of the scope of applicability of this EPDM, that's the first thing. The second one, Chairperson, I would like, at least because we're going to go for the second time in the public comment on this matter, I would like to understand the extent to which we addressed the concerns raised by stakeholders. I've seen the table, I've read the table, but there were proposals or concerns raised by stakeholders, for instance, in relation to the approach taken by the energy regulator, stakeholders indicating that it will be impossible for the energy regulator to implement the approach as or the methodology as proposed. So there must be a phased-in approach that was raised, in the areas that are a priority, which the energy regulator can implement immediately and put a time period. So there is that issue. How was it addressed? The other big issue that was raised by stakeholders was that it will seem to be premature for NERSA to do some form of a total overhaul of the methodology without perhaps looking at the present methodology, look at the weaknesses and shortcomings of the present methodology and try to rather deal with those as opposed to start something that is completely new and something that is very sort of time consuming and where there is no data, to be able to implement what is being proposed. So I'm raising this because it did not come out clearly, so that at least we take the public into our confidence that we have listened to what they've raised to us, and therefore we have looked carefully at it, and this is how we respond to the question of why do we go a total overhaul approach as opposed to looking at what is it that is not working and therefore deal with what is not working and so that we can deal with the problems proportionally as opposed to just bite more than what we can chew, so to speak. So that is the issue that also did not come out clearly for me. And you'll recall that we have also raised that, Chairperson, in other workshops, and you've summarized it very nicely. But when I looked at the document, that summary that you have done, it did not come out clearly in the document, which is something that we've asked before. The fourth issue, Chairperson, was that the energy regulator has other tools that it can use, which can assist. One of the tools was that was mentioned during the public consultation was that we do have the RRMs, so that we can extract information from that tool, regulatory tool, and also the deforms, and be able to fix some of the challenges that we come across. And I'm not sure how we responded to that specific issue that was raised by stakeholders. I'm just recalling some of these, Chairperson, from the hearing itself that we had, where most of the stakeholders were against us going total overhaul. And the fifth issue is that there are other legislative processes that are taking place currently. And if we then go total overhaul, will we be in a position to make sure that there is proper alignment with what may come out of those legislative processes? That is the fifth thing that was raised. But also the fact that there was also a proposed paper that was developed by ESCOM stating that is sort of querying whether the process that we embark on is a process that is worth embarking on if already the things that we need to cure are already the licensees are already doing something about that. So these are some of the things that if we say we want stakeholders to understand the process that we have embarked on and we take them into our confidence, these 5 things for me, they stand out and they need to be clarified when we take this paper out there as a second revision of what we have done previously. Chairperson, I would like those to be clarified by staff members. Thank you, Chair.
Thank you, Madam Massetti. Mr. Mkhize.
Thanks, Chairperson. I'm partly covered on some of the issues by Mfundo here, but I've got a challenge with regard to contextualizing for the sake of the members of the public out there to say that this is a process that we're following in terms of using the rules. I think a cover page would be essential just to clarify how the processes that is being followed, the process that is being followed from our side, so that there is understanding, because we have had some consultations, and it should be clear as to what became of that, and then how then this process fits into that, and process in terms of getting to the finalization of coming up with a new pricing methodology. For me, I find that to be key. And then on the other issues, it's just minor issues I just want to state. I'm saying minor in the sense that they don't affect whether we approve or not approve the publication. It's the 6.4 management's responses. I find some of the responses not to be adequate, but that is a matter that needs to be dealt with internally. Some where we just say things are going to be done in due course and all of that. I think we should be very specific and provide guesstimates. Where we don't have capacity, we should be clear. The response should not just say we don't have capacity, but should deal with how then we want to develop that capacity. And in terms of the plan in table 1, I think let's write it. Let's be truthful in terms of what we want to do there. For example, if you're talking of the development of the rules consultation paper, to put a day there, it can't be. Let's put what the days it took from inception. I'm saying this because someone reading this in the future could easily say that these things are doable to develop that in a day, and I don't think that is doable. So let's just revisit it from the point of view that what we have there is a true reflection of what it takes to undertake those tasks. I will leave it at that. Thank you.
Thank you, Mr. Mkhize. Before I let the colleagues to respond, I think can I guide colleagues here? Firstly, this way that says, if you have to recall, when we started the process, we were trying to target September last year, which didn't happen. So, for instance, the process, it has been delayed a lot. So, Madam Aseti, if we had to look at the issues around phasing in, around questions that may have been raised, it was about September last year. So I think we need to be, maybe, and this talks to Mr. Mkhize's last point about being truthful on the table. The process started in 2021, it's 2023. So some of the numbers might be, some of the indications on this can be misleading. So that is the first thing. I think it's important to note that. It's also important to note that at the time when we were consulting in early 2022 and the ERA amendment process had started, the view was that the matter will go before Parliament in 2022. It has not. It is 2023, towards the end of 2023. Unfortunately, as NERSA, we are guided by the laws that exist. We hope for the best in terms of the laws that are coming, that will clarify matters to come into being. But if they have not, we can't base our plans on because as I always indicate, hope is not a strategy. So I think we need to also look at the times. Yes, where the concerns raised by some stakeholders, limited stakeholders, Madam said, I have to say, at that particular point in time, there were issues raised by those stakeholders, but have those been taken into account? The answer is yes. The issue here is data. Unfortunately, whether we like it or not, it doesn't matter what approach we took. Regulation is about data, but it's about quality of data. So, for instance, the processes that are envisaged both for the in terms of the cost of supply approach as well as this one, it's a 5-step process. To functionalize anything, you need to have data to be able to say which costs, which activities are regulated activities, which activities are non-regulated activities, which activities, especially for Minix, for instance, or for any other licensee, for instance, they may be doing more than just undertaking more than just the regulated activities. To functionalize that, you need data. There is no two ways about that. to classify it as well in terms of what Eskom, for instance, has always been asking for, which I think is going to become critical going forward, especially with the creation of the transmission company. It's the separation to classify costs that are considered fixed or costs that don't vary with output versus costs that vary with output. To be able to say these costs are related to energy and these costs are related to capacity. It is critical that we go down that path. But that needs data. You can't do it unless you want to just do a thumb suck. You can't do that without data. Even in terms of allocating costs to customers, we need those customer data. However you collect it, it doesn't matter what methodology you look at. Those 3 steps, by their very nature, are data intensive. I think sometimes it's the extent of the data, it's the extent of assumptions that underpin a methodology that may vary. But data we can't run away from. So I think that is critical. But I think to just respond briefly, Madam Maseti, to say the phasing in, the reason why it was the shift from September last year to now, hopefully, because there's something as an event that has happened. We now have a transmission company that has been created. It is separate. So what might have applied in respect of a revenue for Eskom as a total entity to what you do post MYPD 5, Eskom needs to know how it's going to deal with MYPD 6 in an unbundled environment. This is what we have. It's a reality that we are now facing, that we have an unbundled environment. Can you still use MYPD which is a bundled MYPD, which is about Eskom going forward? Very doubtful. But nonetheless, the issue here is about saying we have particular thoughts, and I agree with Mr. Mkhize in terms of the context. The rules just simply appear, and it doesn't. There is no context. We need a context to this. But the point is, will we be able to just continue with the past as if we? The answer to that is no. We cannot. The world has changed, colleagues, and yes, we need to contextualize this. And yes, we need to bring our the members of the public into our confidence, tell the truth, being able out there and indicate what challenges we are facing. One of which is simpler than saying we're now going to have, when it comes to MYPD 6, how is Eskom going to deal with this in an unbundled environment? And also then to then say, how does this talk to distributors? Because Eskom is also a distributor. The basis of all of our past was that we only had an Eskom retail tariffs. We didn't set all of the other tariffs. Is that sustainable going forward in terms of not having a clear transmission tariffs, for instance, for those people that want to do wheeling? Is it clear that in terms of the unbundled tariffs, which even if we are actually providing your own electricity, which costs are still that you are still supposed we are liable for, network costs and all of the other costs? Is that clear, or are we still going to continue on the same path? Is this a necessity? But I must say, we're just asking. Let's put it out there, providing the context which is asked for by Mr. Mkhize, providing the correct numbers as what is being asked for by Mr. Mkhize. But we need to consult with the stakeholders, engage properly on these issues, put forward the context, put a proper context into this. The world has shifted. Yes, we have not been given a mandate to do market operations and all of that, but that's direction, hopefully, that this thing is going. But we need to work with what we've got. But I just thought I would actually respond broadly on this, that we need to consult. And yes, instead of trying to push for September last year, this process has shifted. But yes, what is lost here is the context. The rule seems to merely appear from nowhere. It is not. There is no context. That context needs to be provided. I just thought I would start there before I actually hand over to the team, Mr. Ntakeni and the team, to actually respond to questions that I might not have responded to. Mr. Ntakeni.
Yes, thank you, Chairperson. You had covered quite a lot, but to start with the applicability, this is the EPDM is an industry-based methodology. It does not apply only to Eskom. It does not apply only to the distributors. It applies to the entire value chain within the industry. So that is that in terms of the applicability. And then in terms of the issues that the stakeholders has raised in the previous processes, we can bring those issues and show the stakeholders that the issues were addressed, but the development of the regulatory report, which led to the development of the rules, is the process that has took into account those comments from the stakeholders. We are able to pull that template and also include it just to show the stakeholders that the issues were considered. And then in terms of legislative processes, I think Mr. Kumede has touched on those. And then in terms of other tools, like the RRMs and the D forms, those are the information that at the moment is able or can be used to as a base to inform what is required in the EPDM, though they will need to be reviewed, but they are able to be used as a base. Well, in terms of contextualization, I think Mr. Kubede has touched that. We will enhance the document to provide that context. And then even the responses on the table, we will enhance and put more details in terms of the response, Mr. Mkhize. I don't know, colleagues, if there is anything that they may want to add. Thank you, Chairperson.
Colleagues, anything to add? Maybe one thing that I will add is that this process will not go forward without the major participation by Eskom and other licenses. And it's quite clear that there are certain things that may need to start to be the preparation for the submission by Eskom for their application for 2026, for 2025, is that it needs to start now. They need to get some kind of direction. They need to have input into this. So all we are asking is that we consult. There is a proposal on the table in terms of how it's to be done, and it's been put in a rule format. And all that the team is here to ask is that, can we consult? Can we get further inputs on this? Yes, with the context provided. In terms of how we move from regulating a company to regulating an industry, because what EPDM is about regulating an industry, not regulating a company. Now, that's what it's about. Put it out there, get the stakeholders to actually comment on this, engage with this document, guide where it needs to be guided, but again, tackling the content, which is unfortunately has been what's been missing, is that we need to tackle the content. We need are the data hurdles in South Africa? The answer to that is yes. But should those data hurdles be sorted out? The answer to that again is yes, because you can't regulate without data. In fact, the sole purpose of regulating, or one of the biggest issues around regulating, is about addressing this data, the information asymmetry between what the licensees information they have and what the consumers out there, the information that they have in terms of the costs. So, or in terms of both in terms of the costs that the licensee incur, as well as the impact of the costs of the activities by the consumers, how that impacts on the licenses. We need to collect that information so that all parties, we need to address this issue of information asymmetry. So all we are pleading again is one of those where this thing is here only to say, let's consult. Is this a decision on to adopt one way or the other? The answer is that it's no. It's about going out there and engaging with the stakeholders and engaging effectively, taking into account the changes that have come to bear. So that is what is being sought, members, addressing and all of the other issues the team can actually incorporate before this document is actually published. I don't know if there are any further questions and follow-ups. If not, I'll then again, members, just take you to the decision. This is about approving a consultation paper. We need to have a comprehensive pre-hearing again on this and other engagements, have a comprehensive post-hearing, but with the view of then saying, let's get the stakeholder views on this. Let's consult. The only way that we can progress on this, even if it is to then close it and come up with a new approach, if there's a new approach, and it's not stopping, as indicated before, this is not stopping other processes, other proposals that may be put on the table. But to then stop one proposal in the absence of any other, I'm not sure whether that's correct also. Anyway, I'm just asking members, therefore, that we then look at paragraph 17. The question is to consult. And there are indicative timelines there that will also, hopefully by October, end of October, we will take the direction whether to put this thing to and can it completely, or to modify it, or to take any other process going forward. So, members, by show of hands, if we can agree to for the team to consult. So it's on paragraph 17. For paragraph 17.1. Members, by show of hands, can we consult? Advocate Sithole, Mr. Mkhize, Madam Spear. I also support that we consult with all of with the incorporation of all of the issues to Mr. Bukula. Thank you. Team, you've got your marching orders. Please take into account all of the concerns raised by members, contextualize things, but put it forward. Be honest also in terms of where we are. I think that table is truly misleading because the process started in 2021. We need to be quite clear about that. Thank you. You've got your decision. Can we then go to item 8, please? Mr. Shozi, who's presenting this one?
Chair, Ms. Rakhalakane and her team will present. Thanks.
Madam Rakhalakane.
Okay. Thank you, Chairperson. Good morning, members and colleagues. The purpose of this submission is to request the Electricity Subcommittee to approve a temporary exemption for Eskom transmission from complying with clause 7.6.5 subsection 1 of the Transmission Network Code. The ELS is duly delegated as per clause 1.7 of the Electricity Delegation Matrix to approve applications for exemptions from the South African Grid Code. So this application is from Eskom Transmission from complying with clause 7.6.51, which deals with the integration of power stations and network contingency requirements. So section 7 of the Network Code outlines the criteria for network planning and development. And this particular clause requires that the transmission network that connects power stations should be able to transmit the power generated from these power stations under N-2 conditions, meaning that when any of the two transmission lines are out, either due to an outage or for maintenance purposes, the lines that are remaining in service should be able to transfer or transmit the power generated by these power stations. And currently, Eskom's network that connects Kuberg and Ankerlech power stations is not able to do so. But in terms of the remedial action, there are projects that are currently underway to address this challenge. However, these projects have been delayed in terms of their completion dates, hence the application to be exempted from complying with this requirement. So Eskom requires a temporary exemption until the network upgrades are completed. But it must also be noted that under normal conditions, the network can transmit all the power that is generated. It is only under an N-2 conditions that there is a risk that the network will not be able to transmit that power, and therefore they may need to curtail to avoid overloading the network. So given that brief explanation, the recommendation is on page 8, and it is recommended that the ELS approve the temporary exemption for Eskom transmission from complying with clause 7.6.5 subsection 1 of the Transmission Network Code until June 2026, as outlined in table 2, and also to approve the condition for this exemption, which is for the applicant to submit quarterly reports. Maybe just also to highlight that the applicant had actually applied for the exemption duration until December 2026, but the GCAC recommended approval of this exemption until June 2026 because they believe that there was too much buffer allocated onto the project plan. Thank you, Chairperson.
Thank you, Madam. Members, you've got a document before us. Any questions, comments? I don't see any hands. Mr. Mkhize, you found your annotations. I know how frustrating it is to lose annotations. But nonetheless, if there are no questions, members, can I then take you to the decision that is sought? It's quite clear. As indicated, is on paragraph 14, and I think it has been read and explained, has been read onto the record. So members, by show of hands, could we approve that recommendation? Mr. Mkhize, Madam Assetti, Madam Spear, Mr. Pokula. I can't see advocate. And Advocate Tola. Thank you, members. Mr. Palagana, you've got your decision. Can we then, who's taking us through the next item? Taking us on the next, who's presenting the next item? That's the shows.
Chairperson, the next two items, 9 and 10, presented by Mr. Mkhize Jr.
Over to you. We need to find a better way of introducing you, Mr. Mkhize Jr. Yeah, anyway, please go ahead, Junior. Is Mr. Mkhize on the call? Mr. Mkhize Jr. it is. Mr. Khalakan?
Okay, I can maybe take, because he had indicated that he might run out of power.
Please proceed now.
Yeah, so I can maybe try to take them on.
Okay, please proceed. Thank you.
Okay, so the first one, it's a temporary exemption from Appendix 9 applications. I didn't quickly check the agenda to confirm, but yes, the purpose of this submission is to request the Electricity Subcommittee to approve temporary exemptions for Adams Solar PV, Pulida Solar Plant, and Herbert Solar PV Plant from complying with Appendix 9 of the Renewable Energy Power Plant Grid Code. Again, the Electricity Subcommittee is duly delegated as per Clause 1.7 of the delegation matrix to approve exemptions from the grid code. So these 3 plants, they don't comply with the requirements for a 6-yearly routine testing. So the plants were not able to complete all their activities on time due to reasons that are given. I think it's on table 2. So the RPPs have indicated in that table how they will address the outstanding activities and request that they be granted an exemption for the durations highlighted. So I'll move to the recommendations. I think they are on page 9, if I'm not mistaken. quickly.
All right, page 9.
Yes. So the recommendation on page 9, that it is recommended that the electricity subcommittee approve the exemption for Adams Solar and Pulida Solar until January 2024, and for Herbert Solar Plant until 30 June 2025, and also to approve the conditions that will be attached to the exemptions as outlined in paragraph under section 14.2. Thank you.
Thank you, Madam.
So should I just take the next one or wait for a decision on this one?
Let's deal with this one, and then we'll then proceed to the next one. Members, any questions, comments on this submission? And it doesn't look like there are any questions or comments. It's clear enough. Guess we've dealt with a few of these. So members, if I can then take you to the decision that is sought, we are requested to approve and to make those approvals 14.1 and 14.2, and they've been read into the record. So by show of hands, members, if we can approve. Thank you, Advocate. Thank you, Madam Massetti, Mr. Pokula. Apologies, Madam Spear and Mr. Mkiza. Thank you. You've got your decision. If you can move on to item 10 then.
Okay, thank you, Chairperson. So in terms of item 10, the purpose of the submission is to request the Electricity Subcommittee to approve the temporary exemption for Konkusi's PV plant from complying with clause 9, subsection 4 of the RPP grid code. The Electricity Subcommittee is duly delegated as per clause 1.7 of the electricity delegation matrix to approve applications from the industry requiring exemptions from the grid code. This particular RPP is non-compliant with one of the quality of supply requirements for harmonics, so it's currently emitting some harmonics and long-term flicker. So the applicant is planning to install filters to solve this problem, to make sure that these harmonics are filtered and they're not injected into the grid. And they are indicating that they will be able to prove compliance by October 2024. So therefore, they are requesting for an exemption until October 2024. So I'll also move to the recommendation that is on page 6, that the energy regulator, sorry, let me just read that properly. Yes, that it is sorry about that. It is yes, it is recommended that the Electricity Subcommittee approve the temporary exemption for Konkusi's PV plant as outlined in Table 3, which is for power quality and due to expire 31 October 2024, and also to approve the conditions under section 14.2 that will be attached to this exemption. Thank you, Chairperson.
Thank you, Madam. By the way, what does Konkusis mean, and how do you actually spell it? Is there meaning to this word?
I don't know. Sorry, I'm not sure.
All right. I thought maybe it's a word in one of the African languages. Okay. All right, members, you've got the presentation before the document before us. Any questions on it? Comments? I don't see any hands. So with that, can I then take you to the decision that is sought, which is on page 6, the green numbered page 6. And I think the actual recommendations have been read into the record. So I don't have to repeat that word. For some reason, I can't say it. So members, by show of hands, if we can approve. If we can approve those recommendations. Thank you, Madam Spear, Mr. Mkize, Madam Massetti, Mr. Pokula, and Advocate Sitole. Thank you. You've got your decision. Mr. Shozi, and thank you, Mr. Kalagane, for coming in and assisting. Can we then move on to item 11? Who's presenting this one, Mr. Shozi?
This one will be presented by Mr. Hopper.
Mr. Hopper, please go ahead. Take it as read, of course, but please contextualize it properly. Thank you. Over to you.
Okay, good morning, Chairperson, members and staff. Taking the matter as read, the Electricity Subcommittee is requested to note the submission and its attachment and approve the publishing of the NRS 048 Part 9 and approve the attached consultation paper with the proposed timelines for public consultation. And the fourth one was to recommend for energy regulator to note the publication. The ELS is delegated to approve regulatory matters of NRS standards and also approve the request for public comments as delegated on the metrics of the approved delegation by 6.16 and also 6.2. Background of the matter, the NRS 048 standard is termed the Electricity Supply Quality of Supply, Code of Practice for Load Reduction Practices, System Restoration Practices, Critical Loads and Essential Load Requirements. This code is developed to address the need for a national code for real-time emergency and load reduction of supply and restoration of supply following a major system incident. The need for such a code arose after the load shedding was implemented in South Africa for the first time in 2008. And the first edition was approved by NERSA in 2010. The second edition was approved by NERSA again in 2019. Currently, the one that is before us is a third edition, and it has been compiled to reflect the changing electricity landscape in the country with a special focus on the impact of the current national electricity crisis and the need to protect the national grid from inter-ally into a blackout situation or a total collapse of the national grid. What again this code of practice provides is a structured way for utilities to respond to system operator instruction to reduce load, allowing utilities to control how the load is reduced, and also suggestion on ways of managing critical and essential load, and also the communications obligations to the network. The requests for stakeholders' comment are based on the following. The first one being the licensee's responsibilities on maintaining, developing, and executing the load reduction as according to the practices of this code. The other request is for stakeholders to comment on the consideration or variations that are set according to the principle that is of section 4.4 of the main document body. And the stakeholders again are requested to comment that in line with maintaining grid stability and grid integrity, what are other proposed methods of load reduction in making sure that the system does not go into any blackout situation or total collapse. And there is a process that has been set out again on this disaster declaration. The stakeholders are also requested to comment that in case of disaster declaration, the process that has been set out, can it be improved or they see the process being well defined. And approval of this code, firstly, it has been approved by the National Rationalized Specification, which is the NRS Management Committee, and there's been engagement with many sectors that are represented within the working groups. And on the 30th of June this year, the NRS Management Committee concluded that this code of practice meet all the criteria to address the need for a national code of practice for a real-time load reduction and restoration after a major incident, and has been sent out to NERSA to follow up on public participation process, and also to satisfy the provisions of the National Energy Regulatory Act and provision of the Administrative Justice Act. And with that, Chairperson, we can also go to the recommendation, which is on page 6, which is request the Electricity Subcommittee to know the submission and its attachment, and to approve the publishing of the NRS 048 Part 9, and approve the consultation paper with the proposed timelines that have been set out on the consultation process, which is attached as Annex Chap B, And the fourth one, which has been omitted by mistake, it was to recommend the energy regulator to note the publication of the said consultation paper. Thanks, Chairperson.
Thank you, Mr. Copper. I guess the version you have might be different to the one that's published, but the recommendations are on page 7, and I think we should have split them properly. That the first one is that the ELS will approve, the request is for the ELS to approve the publication of the consultation paper. And then, of course, to then, secondly, for the ELS to then recommend to the energy regulator to note the submission and its attachments. Members, any questions, comments on this? It's been on the papers for a long time, but people have been talking about this, but this is NESA's purview, and NESA has not had an opportunity to engage with it. Mr. Mkhize?
Thanks, Chairperson. I appreciate the development of this code. I'll just like to note, because when I look, for example, on page 60, where then it deals with the different facilities, the water supply, sewerage, refineries and fuel pipelines and all of that, mines, education facilities. Just the recent court judgment, does it take that into account? Just want to get clarity on that. And then secondly, sometimes I note the codes as being technical, but still I would like to know, is there scope in a code somehow to be very clear with the penalties that go with the contravening the code, or it's a matter that's left outside to be dealt with in terms of the act? I'm just thinking, would it not assist to be clear in terms of penalties that accompany the violation of the code? Thank you.
Thank you, Mr. Mkhize. Any further questions, colleagues? If not, back to you, Mr. Copper.
Okay, thanks for the question. I think I will start with the second one. The second one, the penalties have been left out from this code. That has to be dealt with the Act. And the first question regarding the recent court judgment that has been made, on page 20 of the NRS document, it has been dealt with. That is to say that if there's any law or legal judgment that has been made, which might be found to be in contradict with this code, the legal or the law judgment does take precedence over this code of practice. But then again, that should also be done with making sure that it won't have any negative impact on the system integrity as well as the system supply. Thanks.
Thank you, Mr. Copper. So I guess what you are saying is that, there's a follow-up, Mr. Mkhize. I was going to follow up on your behalf. Please go ahead.
Thanks. What I want to get is there's harmony, as always, with the judgment, and two, if is it still best to deal with issues of penalties outside of the code? Because there are certain things here, the how the public is aggrieved sometimes by this load shedding, and how, from a point of view of I would say a social contract with the public, Eskom is failing and getting away with it in terms of making sure that there is stable supply. Just want to I was not sure whether your views with regard to that have been, if any. Thank you.
Thank you, Mr. Kopa. Would you want to venture again onto this? I think the question is quite clear.
Okay.
Unless,
No, I do believe that there is harmony with regards to the court judgment. There is nothing that has been said on the court which contradicts what the judgment has said on a high level. Yep. As for the penalties, I do believe that since this is a code of practice, and then the ERA seems to be law to this code of practice, so the ERA takes precedence over the code of practice. Thanks.
Thank you. Maybe what you could do, Mr. Kopa, is just to add this question of penalties and that social contract to in respect of the consultation paper. I think that's in essence where I think Mr. Mkhize was going. Let's ask the public out there what their views are. Well, again, and confine it to say, in respect of what is provided for by the Electricity Regulation Act, and see whether the act itself is sufficient to actually provide that kind of guidance which has been asked. Can we do that?
Okay, there will be added things.
All right. Mr. Mkhize, I'm hoping you'll be comfortable in that, within that space, if that is addressed like that.
Yeah, I'm comfortable because whenever there's contravention, it helps just to be very succinct and clear in terms of the penalties that then get evolved whenever there is that, instead of starting another process to investigate and see what to do, it ends up actually not serving the purpose. Yeah, but I think if to ask a question around that, I will be covered. Thank you.
Thank you, Mr. Mkhize. All right, if there are no further questions, members, can I then take you to the recommendation, which is on page 7, as read, that there are 3 recommendations. It's just that they tend to be a little bit, Mr. Kopa, tend to be conflated because there is a recommendation. Firstly, is for the ELS to approve, is requested to approve for the publication of this code, and to also for consultation, for public consultation, and then to also approve the consultation paper with those amendments that have been requested, Mr. Kopa. And then, of course, thirdly, then to request that the ELS recommends that this submission as well as the attachment be sent to the energy regulator for noting. So those are the 3 recommendations. Members, by show of hands, if you agree with them, if we can approve those recommendations. Thank you, Madam Spear, Madam Massetti, Mr. Mkhize, Advocate Sithole, and Mr. Bokula. Thank you, Mr. Bokula. So you've got your decision, Mr. Kopa, but please do incorporate that question that has been asked by Mr. Mkhize. Thank you. Can we then move on to agenda item number 12, the report on the free basic electricity determination. Mrs. Shotlo, who's taking us on this one? Who's going to be presenting this?
Yes, Nguleni will be doing that, Chairperson. But the context of the report, it's coming out of the approval of the FBE rate and how it's funded, and how it has been escalated over the years. So Nguleni will take us over that. Thanks, Chair.
Thank you. I saw she was struggling to join earlier, but Mr. Kwadi, I'm hoping that you can present. Okay, thank you.
She's here, Chairperson.
Yes. Okay.
Thank you. The purpose of this submission is to request the Electricity Subcommittee to recommend to the Energy Regulator to note the report on the FBE determination, how it's funded, and how the FBE rate of 50 kilowatt would have escalated to date since its inception, taking into account the tariff increases over the years. So the free basic electricity is the amount of electricity that is deemed sufficient to provide basic electricity services to qualifying household. The national government made an announcement on the provision of the FBS, free basic services, including the FBE to households in 2001, which makes provision for 50 kilowatt per month of electricity to indigent household identified by the municipalities. Municipalities have their differences approaches regarding who qualify and who does not qualify when implementing their free basic electricity. In support of this policy, NESA annual review the NFBE rate that ESCOM charges the municipality to supply the FBE to household in the ESCOM supply areas within municipal boundaries. The NFBE rate is the recovery rate that ESCOM charges for providing FBE on behalf of the municipalities, as the funding is only provided to local governments only, but not ESCOM. It is also worth noting that NESA does not have the mandate on the implementation of the FBE, but only implement the DMRA policy introduced in 2003 as required by the Electricity Regulation Act. There are also concern over the sufficiency of the amount of 50 kilowatts of electricity, particularly taking into account the electricity increase over the years. But the current policy remains as stated in the FBE policy that the national emphasis will be focused on providing an amount of the current 50 kilowatt for electricity free to qualifying customers. FBE is funded through the basic service components of local government equitable share, LGES, and this component helps the municipality to provide free basic water, electricity, sanitation, and refuse removal service to poor households. The FBE funding is provided by the National Treasury to local authorities through equitable share allocation. The cost of providing this FBE is included in the MTEF budget allocation of the Department of Provincial and Local Government. The local government equitable share funds are the funds that granted by the national government and are equitably distributed to local authorities to supplement their internally generated revenue and provide the free basic services to poor households. And in areas where, as I mentioned before, that the funding is only provided to local governments. In areas where ESCOM is the supplier, ESCOM provide the FBE on behalf of the municipalities. So in such areas, ESCOM and municipalities get into a contract where ESCOM supply on behalf of the municipality and claim from the municipalities for supplying the FBE to qualifying customers. It can also be difficult to determine how the FBE costs the fiscus per annum because the amount of FBE is bundled in equitable share and it's not a conditional grant. As a result of that, the municipalities then divide the equitable share based on the need within the municipal departments. And then municipalities accordingly fund their free basic services or electricity programs in terms of priorities or divide the equitable share based on the need within the municipal department. It is then the responsibility of the municipality to prioritize spending in their area of to provide free basic services. The table 1 it shows the 10-year trend on how the FBE rate of 50 kilowatt will have ballooned to date from its inception, taking into account the tariff increase over the years. So the table 1 indicates that the first row indicates the actual FBE rate, and then there's seven. I think which row? I think 7th row shows the FBE rate, which would have been if it was increased by the guideline increases over the years. When we look at the differences, there's not much differences in the FBE rate, actual FBE rate, and the FBE rate that if the rate was increased by the guideline. So when we're comparing the two, they compared well because the difference is just a little different in sense when comparing the two. So the recommendation are on page 8 of the document. Thank you.
Thank you, Madam, for the comprehensive presentation. Members, document before us, any questions, comments? Seems like there are none. Therefore, if there are none, can I take you to the recommendation, which starts on page 7 of 8? and it spills over to page 8, I guess. Well, the recommendation is actually on page 8, that the recommendation is for the electricity subcommittee to recommend to ER to note the report on how the FBE is determined, secondly, how FBE is funded, and thirdly, how the FBE rate of 50 kilowatt hours would have escalated to date since its inception. Is not science, since its inception, taking into account the tariff increases over the years. By show of hands, members, if we can approve that recommendation. Thank you, Madam Massetti, Mr. Mkhize, Madam Spear, Advocate Tole, and I also support. I can't see Mr. Bokula, but you've got your decision, Madam. And now let's step off this item and go to item number 13. Mr. Chotlo, back to you again.
Yes, Chairperson. The next person that will be presenting this one is Ukwena, in the absence of Ubuhiswa, but we are here. Ukwena, you can go ahead.
Thank you, Ms. Matlo. Please proceed.
Okay, thank you, Chair. Thank you, Chairperson. The purpose of this report is to note the progress report for Eskom's 3-year negotiated pricing agreement with Sublime Technologies. On 31 March 2022, NESA approved 3-year incentive pricing package for Sublime Technologies in Grill Mpumalanga. The reason for the decision requires Eskom to submit the report 6 months, thereafter every 6 months until the end of the NPA to assess whether the intended objectives are achieved. The table on page 4 of the submission assesses the performance of Sublime against the SEC targets at the approval stage. We recommend the Electricity Subcommittee to note the 6 months progress report for Eskom 3-year NPA with Sublime Technologies. Thank you, Chair.
Thank you, Madam. Members, any questions on the report, comments? The 6 month report. Doesn't seem like there are any questions, comments. By the way, can I just ask Ms. Metlotu, would you know, if we didn't have this NPA, would this company still be operating? Just a high level question.
Based on the applications when at the assessment stage, I don't think the company will be operational.
All right, no, thank you. All right, members, the recommendation starts on page 6 of 7 and spills over to page 7, but I guess, no, it's actually just on page 6. It is recommended that the Electricity Subcommittee note the 6 months progress report on the Eskom's 3-year NPA with Sublime Technologies situated in Kriel, Mpumalanga for the period 1st of October 2022 to the 31st of March 2023. By show of hands, members, if we can note. Thank you, Mr. Mkhize, Madam Massetti, Ms. Spear, Advocate Sitole. I also note. Thank you. Your report is noted. Members, this brings us to the end of the open meeting, and would like to then thank the members of the public that may have followed us throughout this process, and apologize for any hiccups that may have come up. It's only human to err, but we thank you. We thank the members of the public for taking interest in the affairs or in their affairs, and to see how NESA executes its mandate. Thank you, Mr.